Good afternoon, everyone. As you know, Planned Parenthood of Indiana and Kentucky filed a lawsuit challenging aspects of House Enrolled Act 1337, which would have absolutely prohibited a woman's right to obtain an abortion if she was doing so for specific reasons, would have required Planned Parenthood to become the state's mouthpiece to inform women of information that clearly was not truthful, and would have required Planned Parenthood to dispose of fetal and embryonic remains as if they were deceased human beings. Today, June 30th, a day before the law was scheduled to go into effect, District Judge Tanya Pratt granted us a preliminary injunction preventing the law from going into effect, thereby restoring the status quo so that as of tomorrow, women in Indiana will still be able to obtain abortions free from unconstitutional interference from the state. I have no further comments. I'll turn it over to Betty Cockrum, and then we'll take your questions.
I would first like to say that I can't express enough gratitude and joy regarding this outcome. The work of the ACLU of Indiana is extraordinary. That's always true, and I think never more so than today. It certainly is an historic week on this front. What a delight that a couple of really important courts have spoken so compellingly regarding the right of a woman in this country, and specifically now here in Indiana, to have access to safe legal abortion. And I think one of the single most important things that came out of the review by the Supreme Court, that the ruling that was handed down on Monday, was the affirmation that in fact abortion is safe. It's safe, yet here in Indiana, every single legislative session, some efforts are made by legislators to suggest that additional regulation needs to be put in place to ensure patient safety, and we're certainly hopeful that that sort of behavior gets put aside. The only other thing I would say at this moment is there have been people who, because of the second ruling being so definitive and so good for women, have said, wow, this is like early Christmas. I would say, and my friend here doesn't celebrate Christmas, so that's one reason to go away from that, but right?
It's not because I'm a Scrooge.
No, he's not a Scrooge, not at all. He has a great sense of humor. But what I would say instead is Happy Independence Day to the women of the state of Indiana. We get to celebrate our freedoms, and we hear a lot from both the executive and legislative branches in the State House of Indiana about those precious freedoms and how they need to be protected. Never as a woman in Indiana do I really feel like they're talking about me. Today, we are talking about me. We are talking about the 51% of the population that is female, and we celebrate, and thank you.
Thank you. Questions?
In light of the Texas decision from the Supreme Court, Indiana has no privilege requirements not identical to Texas. Is that something that you're looking at?
We are in the process of reviewing Indiana's abortion laws in light of the Supreme Court decision, and we'll see where those stand. At this point, at this minute, however, we'll savor this particular victory.
What you've been able to turn back some other laws passed here in Indiana. How does this fit in with those others, and what you said, Betty, about every year there's always more abortion proposals in the legislature?
I'll let Betty answer that, but since I'm a lawyer, I need to talk first.
In 6-minute increments.
What the legislature has attempted to do here is unprecedented. We have, since Roe versus Wade, a continuing line of Supreme Court cases which say that the woman's right to obtain an abortion pre-viability is fundamental and simply cannot be interfered with by the state. The Texas case, the Supreme Court decided, dealt with issues of regulation and undue burden. This isn't an undue burden case. This is a case where the state of Indiana said, we don't care what the Supreme Court says, you cannot get an abortion if you get it for this reason. That's unprecedented. The court recognized there are no cases in the country that would allow that because the law is completely opposite. And this is a a prime example of what I would think would be a gross overreach by the legislature.
Do you have any reason to believe that the state won't appeal?
That is not up to us.
Betty, what's your opinion if they do?
Do I think that the state will appeal?
And what's your opinion if they do?
Well, that's something we've already speculated on today. I'm not a lawyer, and so I do take these liberties. If they behave as they have historically, they absolutely will appeal, and one has to believe that that's what they will think is necessary to play to their base. It's an important political year.
It's temporary?
Is this
You said
injunction
Independence Day.
temporary?
You called it Independence Day, but is it temporary? You know, it's going to be challenged.
Well, we don't know that it's going to be challenged. There's a time frame in which the state has to respond, but if I were a betting person, I would speculate that they will in fact file an appeal.
And this is, of course, a preliminary injunction. The state is
Yeah, we
free
haven't had the hearing yet, so.
to say we're not going to appeal, but we want to have a trial and what have you. I think, however, the court has made a pretty definitive ruling on the state of the law, and I think, as I said, the state of the law is pretty clear. But we'll see.
The judge issued fairly decisively on the selective abortion ban, but she seems much more conflicted about the fetal remains portion of the law. Are you worried that if it goes to a permanent injunctive hearing, that issue is less clear?
The fetal remains, embryonic and fetal remains portion of the law has a different test applied to it than the prohibition. We felt confident in our argument. The court accepted our argument, and if in fact it goes further, we'll proceed with our argument. I think the court recognized there's something fundamentally irrational about the state treating these remains as the remains of deceased human beings, because they clearly are not.
The president of Indiana Rights to Life said that this is a civil rights struggle for unborn Hoosier children. As the legal counsel for the American Civil Liberties Union, can you just react to that statement?
Of course. Roe versus Wade and numerous cases since Roe versus Wade have made it clear that an embryo or fetus is not a person. And this case is one of a long line of cases that continues to recognize that. The right of a woman to obtain an abortion for any reasons, pre-viability, is a fundamental right of privacy, and the state has no right. Planned Parenthood of Indiana is clear in asserting its patients' rights, and those rights cannot in any way be infringed upon by the state, and that's exactly what this law attempted to do.
Ken, do you have any estimate of how much the legal fees will be that the state will have to pay in this case?
No. The federal law does provide that in a case like this, if plaintiff prevails, our fees have to be paid, even though we are not private attorneys. We are paid as if we were private attorneys. That money does not go to the attorneys. It goes to the ACLU of Indiana, and I do not know.
Betty, when I asked before about, this is a long line of laws that the legislature passed, do you think that's going to continue even with these rulings?
We certainly hope not. We know the Indiana General Assembly will return in January of 2017. We're hopeful that this week alone and some ensuing activity that's bound to take place in the next 6 months prior to their coming back will further affirm that these kinds of that this language, these kinds of bills just should be shelved at this point. Indiana is already one of the 4th most restrictive in the country in terms of access to safe legal abortion, and I think had this bill in its entirety gone into effect at midnight tonight, it could well have put us in number 1 place. That is no badge of honor. It puts women in danger, and it is discriminatory.
Betty, how confident were you that the preliminary injunction would be granted before it came down?
My answer to that question is pretty consistent. The expertise that we get with the ACLU of Indiana, the research that's done before we make a decision, is extensive and well informed, and we're not a litigious bunch, and we don't file frivolous lawsuits. So If we head to court, it's because we believe that it's the right thing to do, certainly, but we believe that we will prevail.
Are you confident if the state does push ahead with the case that you'll be able to prevail?
Yes. Obviously, if the case goes forward, we will argue, continue our arguments, but I do want to stress that what the state of Indiana has attempted to do here is really grossly flies in the face of existing law. And I think the legislature, no less than lawyers, should understand what the law is and are bound to follow the law, and I can't for the life of me understand why the legislature would pass a law that, in essence, overrules Roe versus Wade and Casey and all the Supreme Court cases since Roe. But we'll see.
Betty, what's it been like to see the response from people, particularly women, the movements that this has sparked?
Well, you know, just after the governor signed the law, the bill, and periods for Pence got going, at this point they've got something over 52,000 hits, and that's no small number. And it has attracted a lot of attention, and that's been pretty gratifying. And just today with this news, it's just really it's meaningful that so many people know what's going on, have been waiting to hear, and say thank you. They say thank you on behalf of the women of Indiana, and that's good. We say thank you.
Thank you.
And we say that.
Thank you all.
Thank you.
Thank
Take
you.
care.